We've previously discussed what is meant by your Miranda rights. A quick recap. The United States Supreme Court ruled in Miranda v. Arizona that when a police officer takes a person into custody, the officer must warn the person of the Fifth Amendment privilege against self-incrimination. Self-incrimination is a legal term, meaning no one can force you to be a witness against yourself in a criminal case. The Miranda warnings are familiar to most of us. You have the right to remain silent. Anything you say can be used against you in a court of law. You have the right to have an attorney present during questioning. If you cannot afford an attorney, one will be appointed for you by the court prior to any questioning. Once those warnings have been given, a person may waive, this means give up, their rights and agree to answer questions or make a statement. But unless and until such warnings are given and a waiver is obtained, no evidence resulting from the police questioning of a person in custody can be used against the person in court. Does this mean that the Miranda warnings must be given whenever a police asks a person questions?
No. Voluntary statements are not protected by the Fifth Amendment and are admissible in court. If a person enters a police station and states he wishes to confess to a crime, there is no requirement that police stop that person from speaking to notify him of his rights. Similarly, if a person is questioned as a witness to an event, the officer has no duty to give the person Miranda warnings. This is true even if the answers to the questions might be used against the witness in a later court proceeding. The reason there is no Fifth Amendment protection, and therefore no duty for the officer to give any warnings, is that the person speaking is not in custody. So what does in custody mean? When does asking questions of a person become a police interrogation requiring Miranda warnings?
Well, let's start with an easy one. A person is told they're under arrest, they're handcuffed, taken to a police station, led into a private room, and told they cannot leave. When that happens, they are in custody. The police are required to notify the person of the Fifth Amendment rights before questioning begins. In many situations, however, whether or not someone is in custody is less clear. In determining whether a person is in custody, judges try to answer two questions. What were the circumstances surrounding the questioning? Given those circumstances, would a reasonable person have felt he or she was free to stop the questioning and leave? Well, what do we mean when we say the circumstances surrounding the questioning? There are a number of different factors a judge will review. Those factors could include the location of the questioning, the length of time of the questioning, statements made by the police and the person during the questioning, whether the person was handcuffed or otherwise physically restrained during the questioning, the number and the location of the police officers in the room, the tone of voice used during questioning, the educational level or the mental abilities of the person being questioned, and whether the person was released at the end of the questioning. The best way to explain these factors might be to examine a few possible situations. You receive a call from an officer. She asks if you would come down to the station to make a statement about an incident you witnessed. You agree and drive to the station. Does the officer have to read you your rights when you arrive?
No. You've been asked, not ordered to the station. You arrived voluntarily and are answering questions or offering information without being compelled by the officer to do so. If you refused to come to the station, the officer couldn't arrest you for failing to cooperate. Same situation, but after you arrive, you are taken to an area of the building not open to the public. You are placed in an unlocked room that clearly appears to be an interrogation room. Does the officer now have to read you your rights before asking you any questions?
No. Talking to law enforcement in a private room can simply be for privacy's sake. Unless you've been told that you are not free to leave, you are not in custody. Okay, now you're in the interview room with the officers. They've been asking you questions. You've been answering those questions. The questions make you wonder if the officers consider you a suspect in a crime. You ask to take a break, to stretch your legs, and get some fresh air. The officers tell you they just have a few more questions, and one of them casually moves to stand between you and the door. Have your Miranda rights been violated?
Well, you're getting closer, but without clearly asking to leave and being denied, it could simply be seen as a convenience for you and the officers. Why take a 10-minute break when there are only 5 minutes of questions left? Now you're getting nervous and believe the officers think you did commit a crime. You tell the officers that you have to go. They refuse to allow you to leave. They continue to ask questions. They do not give you Miranda warnings. Now have your Fifth Amendment rights been violated?
Probably. If you are not free to leave and that restriction on your freedom has been clearly expressed by the police officers, you are in custody. Any questioning from that point forward raises Fifth Amendment issues, and you should be given Miranda warnings. To be absolutely clear, however, ask the officers, am I allowed to leave? If they say no, then the best thing to say is, I will not answer any more questions without having my attorney present. If questions continue after that point, the Miranda violation is clear. Even with the clear violation, you should say nothing further in response to any questions except to ask for the presence of your lawyer. Do things change if the questioning is not at the police station? What if you're pulled over for a traffic violation? Can the police ask where you've been that evening? Does the officer need to read you your rights before asking that question?
Yes. The officer may ask you the question, and no, the officer doesn't have to give you Miranda warnings. However, you are not required to answer the question. You are never required to volunteer information to an officer, but if you do answer questions, you must be honest. If you're dishonest, you could be charged with the crime of obstructing an officer. You decide you have nothing to hide and answer the question by stating that you were at a birthday party at a local tavern. The officer asks you to turn off the car and step out. You do so, and she continues to ask questions regarding your activities earlier in the evening. While doing so, she steps between you and your vehicle. You aren't at the police station or in handcuffs, but are you free to leave?
We've entered another gray area. A reasonable person in such a situation likely would not feel free to leave. Answering the questions may lead to incriminating evidence against you. However, judges often will say that until it is clear that you actually are not free to leave, no Fifth Amendment right has arisen. This means the answers you give can be used against you, even if no Miranda warnings were given. Let's go back to the station now. A very friendly officer calls and asks if you'll come to the station as he has some questions to ask you. The officer is vague about why he wants to talk to you. You ask the officer, do I need to have an attorney present? And he answers, that's entirely up to you, but you aren't under arrest, you can leave any time, and you'll be free to go once we're done talking. What should I worry about in this situation?
First of all, any promise you'll be free to leave is an empty promise. Even if the police officer believes it, he has no way of knowing what you'll say in the interview. Therefore, he can't guarantee that you'll be leaving at the end. What if you confess to a serious crime while speaking with the police? Would they validate your parking and send you on your way? Not a chance. The lesson today is simple. No matter how non-threatening an interview with law enforcement sounds, it is always best to have an attorney with you when speaking with police. This is true even if you are the one who starts the conversation. There are too many gray areas where the Fifth Amendment is concerned. When you speak to the police, anything you say can be used against you or your family or friends, for that matter, in a future criminal prosecution. The one statement that can never be used against you is your statement that you wish to exercise your constitutional rights. The best way to preserve your rights is to assert them yourself. Be simple and clear. Am I free to leave? If the answer is yes, then say thank you, I'd like to leave now. If you are pressed to answer any more questions, even one, tell the officers, I want to talk to a lawyer before answering any more questions.
We understand the desire to explain your view of a situation to the police. We also understand that no one wants to be arrested. However, you'll find out the officer's intentions as soon as you assert your right to silence and to have legal counsel present. Either the officers will cease questioning you and let you leave, or you'll be arrested. Asserting your rights is the best way to know whether you are having a discussion to assist in an investigation or whether you are the suspect. Friendly conversation can turn into an arrest in little time. Remember, your constitutional rights will only protect you if you use them. Ask if you are free to leave and ask for an attorney.